हेलो फ्रेंड्स, वेलकम टू सेकंड पार्ट ऑफ डिवोर्स अंडर हिंदू लॉ। जो कि लास्ट पार्ट में हमने डिस्कस करा था फॉल्ट ग्राउंड्स दैट आर अवेलेबल टू बोथ हस्बैंड एंड वाइफ। इन दिस सेक्शन वी वुड बी डिस्कसिंग फॉल्ट ग्राउंड्स दैट आर ओनली अवेलेबल टू वाइफ प्लस डिवोर्स बाय म्यूचुअल कंसेंट एंड फाइनली द कंप्लीट मैरिज बैकग्राउंड थ्योरी। तो ये तीन नई चीज़ें हम डिस्कस करेंगे इस सेक्शन में। सेक्शन वन जो है वो था, जो हम डिस्कस कर चुके हैं, वो था फॉल्ट ग्राउंड्स दैट वर अवेलेबल टू बोथ द पार्टीज, जिसमें हमने एडल्ट्री, क्रूअल्टी, डिजर्शन, कन्वर्जन, अनसाउंड माइंड, कम्युनिकेबल वेनेरियल डिजीजेस डिस्कस करा था, प्लस रिनाउंसिंग द वर्ल्ड और प्रज्यूम डेड फॉर 7 years। ये ग्राउंड्स थे जो दोनों को अवेलेबल हैं, वाइफ और हस्बैंड को। इस सेक्शन में हम ये डिस्कस करेंगे शुरुआत में कि व्हाट आर द एडिशनल ग्राउंड्स दैट आर अवेलेबल टू वाइफ। ओके, लेट्स स्टार्ट दिस थिंग। The additional grounds that are given to wife are mentioned under section 13(2). There are primarily four additional grounds that are given to wife. Now, first one is if there is another wife of the husband that is alive before this act, that is Hindu Marriage Act of 1955 was passed. Under this act of 1955 Hindu Marriage Act, we know that marriage is invalid if there is bigamy. There is no question of this ground available after 1955 that has happened, because that marriage in itself is declared void ab initio because of the grounds of not practicing monogamy. So this clause is only applicable to marriages that happened before 1955, when the husband has another wife that was alive. That is first part. The second ground that is available for wife only is that of rape, sodomy and bestiality. If the husband is accused of any of these three acts, then wife can get a divorce. Now, rape is also a criminal offense under section 375 of IPC. However, section 375 considers marital rape, that is rape of one's wife, only when the wife age is less than 15 years old. If wife is above 15 years old, IPC section 375 does not consider it as a rape. However, the wife above the age of 15 has the recourse of Protection of Women from Domestic Violence Act of 2005 if the husband is accused of any such act. However, at present, wife above the age of 15 is not entitled for divorce under this ground of rape. The second is sodomy, that is having sexual relationship with the same sex or having non-vaginal sex with wife. If you are accused of that thing, then also it could be a ground of a divorce. And lastly, that is bestiality. Now, this is another sad part, that if the husband is accused of having sexual intercourse against the order of nature, that is with animals, then also it is a ground for divorce. These are the second grounds that are available to wife: rape, sodomy and bestiality. Now, the third ground that is available for wife to file for divorce is if any maintenance has been awarded. Now, what it means is, if wife was awarded maintenance under section 18 of Hindu Adoptions and Maintenance Act of 1956 or under section 125 of Criminal Procedure Code. So if wife has been awarded any degree under these two sections, that is section 18 of Hindu Adoption and Maintenance Act or section 125 of Criminal Procedure Code, and wife says that no cohabitation has occurred for 1 year after the said degree has been awarded, so she can now file for divorce. So this is the third ground that is available for wife when she has been awarded maintenance. Now, the fourth ground that is available for wife is the age of wife. Now, if the wife was married before she was 15 years old, she can get this marriage cancelled turns 18 years old. So she has a time period before she turns 18 to cancel this marriage and get divorced. It does not matter if the marriage has been consummated or not, she can still file for divorce. And under exceptional cases, she can file a petition even after attaining the age of 18. That is also available to wife, but under exceptional cases. So moving on, till now we have discussed only the fault grounds that are available to husband and wife for both the parties, and fault grounds that are available only to wife. So that is the first primary reason why divorce happen, is because of fault of any one party, that we have already discussed. Now moving on, the second primary reason why divorce is given is irretrievable marriage breakdown theory, that is mentioned in the section 13(1)(a). Now what happens here is, whenever two parties go to court under any fault ground, what court does is it tries to save that marriage by giving a degree of judicial separation, which is mentioned under section 10. Now the degree of judicial separation is, the grounds under which degree of judicial separation is given are similar to the grounds that are given for divorce. Both are mentioned under section 13(1). So the grounds of judicial separation and that of divorce are similar. So here what the court does is, it gives off a cooling off period to both the spouses to think things over, and it passes a degree of judicial separation. तो डिग्री ऑफ जुडिशियल सेपरेशन में होता क्या है कि कोर्ट कहते हैं कि हाँ, हम समझते हैं कि आप दोनों एक दूसरे के साथ नहीं रह सकते हो, फॉर वट एवर रीजन्स आप नहीं रह सकते, लेकिन हम अभी आपको डिवोर्स नहीं दे सकते, बिकॉज वी कंसिडर मैरिज एज अ सैक्रेमेंट और वी आर ट्राइंग टू सेव दिस मैरिज. तो वो कहता है कि वी आर गिविंग यू अ डिग्री ऑफ जुडिशियल सेपरेशन, जहाँ की आप लोग दोनों अलग अलग अब रह सकते हो और आप इन चीज़ों को सोच सकते हो कि मुझे डिवोर्स चाहिए कि नहीं चाहिए. यू वुड बी कंसिडर्ड एज हस्बैंड एंड वाइफ अंडर दिस पीरियड ऑल्सो. जुडिशियल सेपरेशन में भी आप हस्बैंड और वाइफ ही रहोगे, लेकिन आपको साथ रहने की कोई ज़रूरत नहीं है और आपके पास 1 साल का टाइम पीरियड है. तो अगर 1 साल बाद हस्बैंड वाइफ दोबारा कोर्ट के पास जाते कहते हैं कि नहीं सर, हम साथ नहीं रह सकते और 1 साल तक हमारे बीच में कोई भी कोहैबिटेशन नहीं हो पाया है, तो कोर्ट कहता है कि हाँ भाई, अब तो ये मैरिज हद पार कर चुकी है एंड इट हैज़ बीन इरिट्रेटिवली ब्रेक डाउन, और वो डिवोर्स की डिग्री दे देता है. नाउ द सेकेंड decree that a court can pass is that of restitution of conjugal rights under section 23. We have discussed this in another video, you can go check that out. But in brief, what happens here is, court tries to bring back husband and wife who have been living separately, and it says either to husband or to wife to return back to their matrimonial home and live together. So after passing of this decree of restitution of conjugal rights, no cohabitation happens, then court can grant a decree of divorce. So this is the second part, that there is no resumption of cohabitation after passing of restitution of conjugal rights, then a decree of divorce is granted by court. So ये दो reasons हैं that are of complete irretrievable marriage breakdown that are mentioned in the section 13(1)(a). Now the third primary reason for divorce is divorce by mutual consent, that is mentioned under section 13(b) of Hindu Marriage Act 1955. The first two reasons we've already discussed, that is fault grounds and marriage breakdown theory. This is the third part, that is divorce by mutual consent. जहाँ पे husband wife they both understand कि they cannot live together as a couple and it is better to part ways. It's a mutual decision between these two. They are not blaming each other for the state of their marriage, and they just want to live separately and move on with their lives. Here, they file a joint petition to a family or district court for divorce between them. This is a joint petition, and it is filed on the grounds that both the parties are living separately for a period of 1 year or more, and that they have not been able to live together, and they have mutually agreed that the marriage should be dissolved. So on this ground, a degree of mutual consent is filed, and after filing the affidavit in a family court or a district court, The court adjourns the matter for 6 months. It gives a 6 months cooling off period for husband and wife to think things over. And after 6 months and before 18 months from filing the matter, the parties should again present themselves to court and make a second motion for mutual consent of divorce. And if the court is satisfied with the petition, it grants a decree of divorce from the date of passing this decree. And from that moment, the husband and wife are separated and divorce is finally completed. Now, this cooling off period of 6 months is a discretionary provision and not a mandatory provision. This has been decided by Amardeep Singh versus Harveen Kaur 2017 by Supreme Court, where it is said that it is not a mandatory provision but a discretionary provision, and it depends from case to case. If the parties to the marriage have reached such a stage where it would only increase their agony, then this provision should not be provided, and a decree by mutual consent is enough to end that agony. So, this is all about divorce by mutual consent that is mentioned in the article section 13B of Hindu Marriage Act 1955. So, friends, we have completed all the three primary grounds of divorce under section 13 of Hindu Marriage Act. Those are fault grounds, where additional grounds are given to wife. Second is complete marriage breakdown theory, and the third one is mutual consent. I hope you like this video and have learned something. I will see you in our next video. Till then, take care. And if you would like to practice some additional questions related to this section, that is mentioned on our website and also on the description, so you can check your knowledge from those Q&A. Till then, take care. Bye bye.